Okay, this is the Painesville Township Board of Zoning Appeals. We're going to call this meeting to order. Normally, on a meeting at the town hall, we do the Pledge of Allegiance, but because of the virtual situation here, we will forego that. Rachel, I'm going to ask you to call the roll of the members of the Board of Zoning Appeals, if you would, just for the record.
Okay. Ken Sullivan.
Here.
Dave Enzera.
Here.
Randy Van Buren.
Here.
Dave Lindrose.
Here.
And Chairman.
Here. Okay. Jeremy, are you there?
I am.
If you would, at this time, explain to everybody who plans to testify what you need to do, and then swear them in for the record, please.
I will do that, Mr. Chairman. For everybody that is here to testify for or against any of these zoning appeals, this is a quasi-judicial proceeding. Any party who wishes, after a decision is made, to appeal this decision, that decision can be appealed to the Common Pleas Court. Because of that, we must create a true and accurate record of these proceedings, and the court would use that record to make a determination on that appeal. And for that reason, we will have to swear in anyone who will be giving testimony for or against any of these appeals. So at this time, I'm going to ask everybody, we will dispense with the standing. However, I'll ask everybody who will be testifying for or against any of the zoning appeals that will be heard tonight to please raise your right hand. And I will ask, and you will say I do. Do you swear? Sorry? Yes, please. Not a problem. Thank you, Sean. I appreciate that. So everybody, you will say I do after I give you the statement. And I will ask, do you all swear or affirm that the statements that you will give tonight will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
I do.
I do.
I do.
I do. I do.
Okay. Thank you, everyone. I'll turn it back over to you, Mr. Chairman.
All right, thank you. I let the record show that everyone has been sworn for the hearings. So, Rich, at this time, where's our secretary again? If you could please read case 20 BZA 19.
Oh shoot.
Tom?
Yes.
I thought I heard you ask for case 20 BZA 19. But our cases tonight start with 20 BZA 10.
Never mind. Those are the minutes. Or those are something else.
Okay.
What about size?
Almost got me there.
Yeah, really. Sorry about that.
Oh no, you're fine.
20 BZA 10.
10. Okay.
It
Applicant
was 10. I
Agile
just didn't
sign.
read it right. 20 BZA 10.
Okay. Applicant Agile Sign and Lighting filed a variance application for property located at 2183 Mentor Avenue. The request is to allow installation of a 60 square foot illuminated sign cabinet on a pole with a setback of 18 feet from the Mentor Avenue right-of-way and a setback of -7 feet from the Wellesley Boulevard right-of-way in violation of section 28.05 B3, which requires a minimum setback of 20 feet from any street right-of-way for a sign of 16-foot overall height.
All right. Let the record show that our zoning inspector is correct in asking for a variance in this application. So Rich, you wanted to do a roll call of everybody involved in this application to see if everyone's here to speak for this?
Yeah, Tom, it's important for the zoning secretary to have a full record of all the active participants in tonight's hearing. So my suggestion was that anybody who intended to speak on any particular case on a case-by-case basis, please identify themselves with a full name and residence address.
Okay, all right. All right, so is there
Chairman?
anyone to speak? Yes,
I'm sorry to interrupt. I'm sorry, my son was calling on my FaceTime for a second. What did you want me to put on record?
just that everyone was sworn.
Okay,
Okay.
got it. Thank you.
All right, so is there anyone to speak in favor of case 20 BZA number 10, please? Again, if you would state your full name for the record.
Good evening, everybody. My name is Tion Belknap, and I represent meeting at 35280 Lakeland Boulevard in East Lake, Ohio, 44095.
And I'm Lou Belknap at 35280 Lakeland Boulevard, again representing Agile Sign for Sleep Outfitters.
Okay, do you want to just review what you're looking to do here?
Sure.
Yes, so we are coming before you today to install a sign and ask for a variance for the signage that we have proposed at 16 feet. The code does allow 12 foot, so we'd be asking for that additional footage, as well as the additional height, as well as the setback for the right-of-way on Wellesley. It does meet code for Menor Avenue setback, but it would be within 7 feet of the Wellesley setback. So we would also be asking for a variance for that.
One of the important things was the fact that they're trying to get it out of the planting area and the parking area. That they actually have a corner there, as you see at the plot map, that they actually have flowers or a bedding. The problem with the sign being the way it is, they're afraid somebody might come through with a U-Haul or a truck or something like that and hit the sign because it's a very tight corner. So they're asking to put the sign on the outside edge of their parking curbing lot, which would put it into the right of way of the township's road. That's the methodology of them asking for that. They're just afraid of putting something up there as a tenant sign. It's going to get parked by somebody's truck.
When Mr. Belknap, when would they like to proceed with this? Just out of curiosity.
Well, they wanted to have it up already. You know, I mean, it's something that they're already open. They have a wall sign now, and
Okay.
they've been looking at this probably for 3 months now, and they've already talked to my coworker from January. Rich and I have had several conversations about different things for it. And this is what they've come up with their plot survey and their engineers, and they are requesting to do it this way, just to keep it out of harm's way of traffic and trucks.
All right, good. Thank you. Anyone else to speak in favor of the request? Anyone opposed to the request? Any questions from the board members of the applicant? Would someone like to make a motion, please?
I'll make a motion to approve BZA case 20 BZA 10 as submitted.
I'll second.
Hey, Rachel, did you get who made the motion? Who seconded it?
No, I did
Ken
not.
Sullivan
It
made the
froze for a
motion.
second. Ken, okay.
And Dave, you're the one that seconded it?
Yes.
I did.
Okay, Dave and Zara seconded.
Both days.
Or David.
Pick a date.
Any
All
day.
right, so Rachel, if you would, the motion's been made and seconded. If you would call the roll, please.
Okay. Randy Van Buren,
Yes.
Dave Lindros,
Yes.
Ken Sullivan,
Yes.
Dave and Zara,
Yes.
and Chairman.
Yes. The fact that they want to do this right away, I think we might as well just go ahead and make a motion to journalize this decision so they can move forward with it right away.
I'll make the motion to journalize case 20 BZA 10.
I'll second it. Ken.
Okay. Did you get them, Rachel?
Yes, I did.
Okay, so if you'll call the roll again for journalization of this. Just for people in the audience, that just means that they can move forward without having to wait till the minutes are approved at the next month's meeting.
Thank you very much.
Okay. Ken,
Yes.
Dave Enzera,
Yes.
Randy,
Yes.
Dave Lindros,
Yes.
and Chairman.
Yes. Okay, thank you, Belknap.
Oh, thank
Thank
you.
you.
You're welcome to stay, or you can sign out, whatever you'd like to do.
We're gone. Thank you.
Bye.
Okay,
Bye, Rich.
bye-bye. All right, Rachel, if you would now read case 20 BZA 11.
Okay. Applicant EK North Creek LLC filed a variance application for property located at Blaze Nemeth Road. The request is to allow construction of a 4,800 square foot building with a proposed clearance on the left sideline of 5 feet and a proposed clearance on the right sideline of 38.82 feet in violation of sections 26.07A and 26.07B, which require a minimum side clearance of 25 feet from non-residential and or non-recreational property lines and a minimum 50 feet buffer in addition to a 50-foot clearance totaling 100 feet of clearance area from a residential or recreational property line.
Okay, again, I see no error in our zoning inspector requiring a variance for this. Is there someone to speak in favor of this request, please?
Yes, Yvonne Lacqua with EK North Creek LLC at 1895 Blaze Nemeth Road, Painesville Township, Ohio 44077.
Okay, explain what you'd like to do, please, if you would.
Okay, we are requesting a variance and a combination variance buffer together. Obviously, looking at the print, the lot is a very odd shaped. It is not square. The building that we want to build will not meet the requirements due to the shape of the parcel. Also, we're completely out of room of where we're at now. We have several buildings, but we're completely out of room ourselves for our company. And we had a couple choices. One was we could build a very nice building over there with very nice landscape, which would bring in approximately $6,000 a year in property tax. We would leave all pines along the side of the driveway there at North Creek Drive because the property line runs along North Creek. So we would keep all the pines there along with the thick shrubbery. So it would kind of hide the building and keep the entrance still secure. Also, we wanted you to know that the lots on Blaze Nemeth were plotted in the 70s when the lines, property lines could be, right to, the building could be right to the property line. Now the lots being 75, 80 foot feet and the zoning requiring being 25 foot of the yard, we can't build anything over there. And we've been paying property taxes on this property for several years. It's been in our family for several years and we'd like to build a nice building there.
Okay. Any board members have any questions?
We've already did hard soil testing over there. We spent quite a bit of money on the properties over there, making everything look nice. Now we're just looking to get a variance so we can build, another building. And if you guys drive by, you'll see all of our properties are well kept, very nice properties.
Okay. Anyone
What will
else?
you be using the building for?
Basically, we want to have our own freestanding building because our office right now, we have office and warehouse space, and we have a lot of tenants behind us. And we have actually no room for our own equipment. We have to move out equipment to get pieces of equipment in and out. So we kind of want to build our own freestanding building. So my office and all of our equipment and everything will be right there. So we'll have our own freestanding and we won't have, you know, any tenants or anybody attached to us. So basically, it's just basically going to be office, my office, and storage for all of our equipment.
All those buildings that are there now, you are not in those buildings? Someone else is in those buildings?
No, those are all rental properties. We own all those buildings, but we have Levine Ford Walls in one. We have a trucking company in the other are mini storage units that are filled. And then the building next to that one is where my office is. And we have about 2,000 square feet for all of our equipment. And my office is about approximately 2,000 square feet. But then attached to us behind us are all like 2,000 square, 1,500 square feet, 1,200 square feet units.
So your office is 1895, Blaze name it?
Yes, yes it is.
What will become of that building if you were to move out of it?
Well, what we'll do with that is we're going to rent it. We'll rent the office and warehouse space there because we get a lot of calls for, you know, office and warehouse space. So that wouldn't be a problem, you know, renting that out. But that's what we'd probably do with that building. We have them all. They're all filled right now. And we're in the front office with the small warehouse connected to our office, and all the other buildings are connected to that. So we kind of want to have a freestanding, our own building.
Could you describe for me, and maybe I missed it in the PDF document, but where this new building would be located on that property?
Harry, can you handle that question?
Yeah, my name's Harry Jones, and I'm with Jones Surveying. Can you hear me?
Yeah.
Barely. Yeah, we can hear you.
Okay, barely? Okay. And the building's going to be to the west side of the property. We're beyond the minimum setback, but it's going to be to the west side. It's just an odd configured lot. As the lot goes back off of Blaze Nemeth up North Creek Drive, it narrows down as it goes to the back.
Correct.
We're trying to keep the building to the west of North Creek as far as possible.
Got it. Thank you.
You're welcome.
All right, is there anyone else to speak in favor of the request? Anyone to speak against the request or opposed to it?
Hello, my name is Lindsay Rubel, and I'm an attorney from Otten Associates. And my business address is 1300 East 9th Street, suite number 1520 in Cleveland, Ohio. And board members, respectfully, I am here on behalf of the North Creek Condominium Unit Owners Association, who requested that I attend this hearing on their behalf. And the primary concerns of the association in this instance are that where the requested building is proposed to go, it's really only 9 acre parcel, and it's going to have a 4,800 square foot footprint on that particular parcel, and it definitely is an irregular lot. But the reality is that this land has been in the family for several years. At least that's my understanding, that the applicant's family has owned this property and has actually developed the North Creek Condominium Association. So this subdivision of lots was actually created this smaller parcel, which they're now seeking a variance for. So I'm here on behalf of the 173 families who are in a bit of an industrial area, but use this particular driveway where this proposed building is supposed to go right alongside as their primary, actually only means of ingress and egress to the association. And a lot of those owners spent a lot of money on 173 condominiums, anticipating that there would be some sort of buffer zone, which is currently forested on either side of the association. Right now, I believe that the two vacant lots that are owned by the applicant have North Creek landscaping on them. North Creek currently maintains it, is my understanding. And I'm just here because I think in looking at the factors, this current property, it's been recognized by the county as essentially an unbuildable lot. The county's valued the market value of this particular property at $4,800, and that's not the reduced percentage. That's the fair market value of the property is $4,800 that the county has determined, and the taxes have been around $150 a year. And it's the association's contention that this particular property was meant to be a buffer between those industrial properties into a residential area. So I know that you as the board have to look at several factors, looking into the substantial difficulties test as to whether or not this variance should be granted. And one of the issues that I wanted to bring to your attention, will this property yield some sort of reasonable return for the applicant, or can there be some other beneficial use of the property without the variance? Well, my contention for the board would be that because the applicant created this subdivision of lots and created the North Creek Villas condominiums, that they've created the condition that they're now seeking a variance for, and that it was known pretty much all along that this would be an unbuildable lot. They've sold many condominium units, 173, at what I've calculated to be at several $1 million worth of properties that they've developed and done a really nice job with that subdivision. But this is going to be a substantial variance. We're taking or proposing to take a 100-foot buffer all the way down to 38 feet. And we're taking forested areas alongside of the residential entrance to this property, and we're going to cut down all the trees and the vegetation and put in a building that's going to be large and commercial, and it's going to be sitting right there on the property line. And this,
excuse me, but we've offered the management and the people of the condo association to purchase these lots several times in the past, because we're not going to pay property tax. They don't pay rent to have their signs on our property. We don't charge them for anything. All we want to do is build a building. It would be hidden in there. They won't even see it when you pulled in, because all the trees will still be there. All the vegetation along there, we're going to leave by the trees as much as we can where the building is going to go. Honestly, that board has been fighting us on everything all along. I mean, we've been wanting to do things with this property, and they want to step in, but they don't want to purchase them. If they want to preserve them, then why don't they buy them off my family? I mean, this is a battle that's been going on back and forth. And you know what? We built that condo complex in there, 172 units, but the county cannot forget that they're collecting $344,000 a year in property tax because my family built those. So because we want to build a building, these people are all going to be upset. That's not fair to us. We have done everything that we possibly can have done for that association, and they don't want to budge. So, I mean, we need space. We want to utilize our property in the best way we can. If we can't build a building, we're going to cut the trees and everything down anyways and use it to park our equipment there, because we need somewhere to place all of our equipment. I'm sorry that they're upset with the fact that we own both of those lots. Okay. But when we cut through there 20 years ago, okay, we weren't thinking about the building on those lots at that time. we were, concentrating on building a beautiful condo complex. And
Sure.
we still own condos in there. By the way, we still own, condos. We owned 36. We've been selling them constantly. We're down to 6 units now. We're trying to, sell and get out of there now so we can, do bigger, better things. And we just want to have our own freestanding office right there. There's not going to be any tenants in there. It'll be me and Steve. Those are the only 2 people who are there. We have 1 service guy and our equipment. So I can't find why that would be such a horrific deal to this complex.
Well, and respectfully, ma'am, I know that you did offer.
This is Tom Hill again, real quick. Lindsay and Yvonne, when you do speak up, just identify yourself again, please, for our secretary, so she knows which one of you 2 is speaking.
Absolutely.
Okay.
I apologize.
All right, thank you.
Rachel, this is Lindsay Rubel again, the attorney for the association. So respectfully, the applicant and her family did offer to sell the property to the association. At the time, in discussing the issue with the management, the board, and the owners, it was substantially higher than we thought the fair market value was. As I stated earlier, the market value that the county has it at is about $5,000 because it's pretty much been deemed an unbuildable lot. And we'd have to get 75% of our membership to consent to that. And I don't know if any of you have ever lived in a condo association or a homeowners association, but you know that getting 75% for anything is like pulling teeth.
Yes.
So we did not think that it was going to be feasible. But here again, we're concerned about the residential character of that particular neighborhood and the buffer that is supposed to be between the residential lot that is the entrance to the association and any proposed building. So lastly, one of the factors that I know the board needs to look at is whether or not the variance would preserve the spirit and intent of the zoning requirement, and whether substantial justice would be done by granting the variance. And here I would say that we are not in a position where the zoning requirement intent is being upheld. We're supposed to have a buffer in between commercial property and residences for this reason. And our concern is that the residential character of the area will be eroded. Some of that, the wooding there, or wooded lot there, acts as a buffer to Route 2. And we don't want to put ourselves or the township in a position where we're saying that it's okay for a developer to come in and subdivide large parcels of land and sell off beautiful condominiums, but then if they subdivide their lots into unbuildable lots, that we have to ask the township or the county in whatever respect to grant these big variances that would erode the residential character of the property. And in this case, it's concerning what are now 172, 73 tax-paying families at North Creek Villas. So I would respectfully request that this board consider declining the request for a variance. Thank you.
All right, thank you. This is the chairman again. I just want to remind the board members that this is an area variance, and there's a precedence been set by Duncan versus Middlefield many years ago. There are 7 standards that need to be met, and I think probably most of you have those. And you know, if you need time to look at them, you can do that. And I think Lindsay has brought up some of the points there. You know, from that precedence that was set with Duncan versus Middlefield. Is there anyone else to speak in favor of or against the proposed variance? We've heard from Mrs. Ilakwa and from Lindsay. Are there any questions from the board?
Well, can I have one more thing? This is Yvonne Ilakwa on the record. I mean, the property is zoned industrial. So, I mean, And yet there's no storm, there's no sanitary, sewers or septic approval is going to be very questionable over there also. And the constant truck traffic that we have to deal with the garbage trucks going up and down the road. I mean, that road is all residential area. And those lots are zoned residential, so, I'm sorry, are zoned commercial.
Do you have any idea how far away that your first building is from the North Creek Drive?
Let's see. We're probably about, this is Harry Jones. We're about 54 feet off the edge of the pavement at the corner of the building.
What, to North Creek Drive?
Yes, to North Creek Drive, right. Because we have a 32-foot or 36-foot setback, plus it's probably about another 18 feet from there to the edge of pavement, which would be about 54 feet.
Again, Harry, I'm looking at the drawing from Jones Surveying.
Yes.
Drawing number 19-300.
Yes.
You have that? Maybe we
Yes,
can
I do.
clear this up. This is the drawing that's in all our packets. Maybe we can clear up exactly where we're looking here.
Mhm.
On the left side is Blaze Nemeth Road.
Yes.
The proposed building is sitting the 5-yard side yard clearance. It looks like it's sublot 2. Is that Mike and Martha Jones? Is that a residence there, or is that part of the condo association?
No, that is a commercial building.
Okay.
Mr. Chairman, this is the zoning inspector. That parcel owned by the Joneses is zoned I2 heavy industry, and that is the use that the property is being put to.
Okay. All right. Fine. And then on the drawing, you show the I would say towards the right side of the building, shows 38.82 feet. And then, Mr. Jones, you're saying there's another 18 foot of pavement before the road?
There's another 18 feet before the pavement.
Or before the pavement, okay.
Right. So it'll be the 38 plus the 18, about 56 feet to the edge of pavement. That's where the corner of the building will be.
And since we're talking about zoning, Mr. Chairman, the zoning inspector wants you to know that the private road, in addition to some property which is unpaved that is part of the roadway, is zoned R4, multi-dwelling, multi-unit residential use.
Okay, that's to the, as we're looking on the drawing, that's to the right, correct?
Correct. If we figure the frontage is going to be on Blaze Nemeth Road, the private roadway into the North Creek Condominium Association would be to the east or the right-hand side.
I'm sorry, I missed that. Okay.
Tom, I said if you figure the frontage for the building, the entrance for this proposed building will be on Blaze Nemeth Road.
Mm-hmm.
The roadway for the North Creek Villas Condominium Association would be to the east or on the right-hand side of
Right.
that piece of property.
Okay, I got you.
So yeah, that was going to be my question, Rich. It wasn't clear looking at the drawing where the access road is going to be to get to the building that was going to be built. They're saying it's going to be off of Blaze Nemeth Road, heading north towards the building.
Correct, correct, and toward the west side of the lot line.
On the drawing, if you turn the drawing sideways, it looks like there's some the entrance and then some parking places and then the building. Is that what you see?
There's the entrance and some parking spaces along with a trash enclosure.
Yes.
And then the entrance to the building would be behind that.
Gotcha.
Okay. I
Hey,
drove by it briefly and looked at it from Blaze Nemeth Road this morning. In the area between the corner of the building, there's 38.82 feet. It shows a septic tank, a dosing tank, utility easement. Is that planted in there now with trees? Mr. Lacqua?
I'm sorry. Yeah, there's trees there now.
Okay.
There is no septic tank in there yet, or dosing tank, not yet. No, that's where we plan on putting them.
All right, any questions? Any other questions from the board members?
am I still live? This is the zoning inspector again, being
Yeah,
a typical zoning inspector. I heard Yvonne Ilakwa mention how EK North Creek is being crowded out of their buildings by their tenants. I have this one driving question. Do any of those tenants actually have zoning permits to occupy those premises?
Probably, yes.
Okay, funny they don't show up on the township records.
Well, that's their responsibility. That's in our lease.
Well, that could be in your lease, but in our zoning resolution, that is also your responsibility as the property owner.
So
just so we all stay on the same page.
So you're saying all the tenants that rent over there don't have zoning?
I have not seen any zoning permits for zoning use and occupancy for that address known as 1895 Blaze Nemeth Road in our zoning database. Now, there could be reasons for that, but we'll explore those. I just wondered if you as the property owner were pretty sure that all your tenants did in fact secure zoning permits.
I don't know. I don't know. It's in our lease. It's their, like I said, it's their responsibility.
Okay.
So just so I'm clear, Alakwa's, you owned a bunch of this property. I'm just going to do a general overview here. You owned a lot of this property, subdivided it. You left this piece. You left this lot.
Actually, I did not. Our father did, and he passed away and left us. Yes,
and you left this lot.
He developed Ed Kovacek. Our father developed the properties out there. He did the condo complex. He passed away 5 years ago, and we got handed over all these properties. So we're doing what we can with them. We have spent hundreds of thousands of dollars on those properties out there on Blaze Nemeth Road that the garbage trucks come up and down, and garbage we constantly pick up our properties. Our properties, if you come out there, are very well maintained. We put all new roofs. We have done all new driveways. I mean, we've done a lot of work out there. We've made it look really nice. When Ed and Beverly owned it, the other Great Eastern owned it, it was trashy. It was trashed. We took it over, and we have put all our hard-earned blood and sweat out onto Blaze Nemeth. Now, you don't want to give us a variance, that's fine, but we're still going to do something with the property. So either way, either we get a variance or not to do a building, we still have the right to cut down trees and park equipment there. And if that's what we need to do, then we will do that. I mean, but I don't know why this has got to be such an argument with the zoning board that I've been going through this for several years now. I went through the property on the other side because the people at the condo complex put a block there. And I know that's exactly what's going on right now. That's why they have their attorney here to speak for them. Okay? I'm not stupid. I mean, I've been going through this with the management company for years. They don't pay us rent. to have their signs on there, I can rip them all out. I can do that very easily. Just get rid of all the signs and clear the lots. They don't pay rent. They pay us nothing to have them signs on the property. We've offered them several times, buy them. If you guys want to preserve the property, then just buy the lots off us. We're paying the property taxes on them, not them.
Okay, I understand your concern, Mrs. Luck. Well, we're in here, and no one's out to blackball anybody. The board of zoning appeals, they have guidelines they have to go by. You know, if you've got an argument with the other people, if you can maybe solve that by yourselves, that's something. But, and again, I'm just reminding the board, reminding everybody in the audience here, any proposal here is going to be made to the positive, and then the board has a decision to whether they want to vote yes or no on this. Is there the size of this building, is that the minimum size you need to store the equipment you're talking about?
Well, that's basically all we could put there, to be honest with you. I mean, we would like to go bigger, but with the way the property, well, we could go smaller, but we really could use that size.
I'm speaking for myself when I look at it, and this is an extreme variance as far as I'm concerned. And it's an industrial piece of It's an industrial piece of property. Once that building's built, you move on. That could become a chemical factory. It could be, go through our zoning resolution on I-2. Once it's built and we gave that variance, that property can become anything that fits I-2, correct, Richard?
Correct.
That's very concerning to me.
All right, do my board members here, do you have Duncan versus Middlefield in front of you by any chance?
I do.
Would you like me to read the 7 conditions just so you'll?
Sure.
Yeah.
All right, this is conditions that the board is required to review for an area variance. Number 1, whether the property in question will yield a reasonable return or whether there can be any beneficial use of the property without the variance. Number 2, whether the variance is substantial. Number 3, whether the essential character of the neighborhood would be substantially altered or whether adjoining properties would suffer a substantial detriment as a result of the variance. Number 4, whether the variance would adversely affect the delivery of governmental services, for example, water, sewer, garbage. Number 5, whether the property owner purchased the property with knowledge of the zoning restrictions. Number 6, whether the property's owner's predicament feasibility can be obviated through some method other than a variance. Whether the spirit and intent behind the zoning requirement would be observed and substantial justice done by granting the variance. So again, those are 7 guidelines that we need to look at. Just one question. Randy back?
I am here, Mr. Chairman.
All right, thank you.
For a reason, I lost video conference, so I am on the line.
All right, thank you. All right, any other questions from the board? Any other comments from the applicant?
I have one question. So you offered the association to buy this plot of land, and the offer, or what you considered a fair offer, was outside of the range of what it was worth, or what's going on with that?
This is Yvonne Alacqua. I know that they were offered when Beverly and Ed owned it. They were offered to buy the lots, and I know Bev at the time was asking quite a bit for the lots, but since Ed's passed away and he's left these properties over, we've had meetings with them, and I know that they weren't asking a whole lot for the lots. I'm not quite sure what the offer was. I was not in that meeting. I'm sure I could get the offer from Steve, but we've had quite a few meetings with, they came into our office, and we just never got any answer from them. They never gave us a yes answer. They never gave us a no answer. They just never got back to us. So we've always just been left hanging on it.
And this is Lindsay Rubel, the attorney for the association. I was not present at these particular meetings, but it's just my understanding from my discussions with the board and the association's property manager that the offer that the owner of those parcels, that the applicant's family, that the offer was about 5 times as much as we thought the market value was. So it wasn't a viable option.
Okay. Anyone else to speak in favor of or against the request? Any other questions from the board?
Just a comment, Mr. Chairman. Again, listening to both sides, you know, this board always tries to talk with folks that come before to see if, like in a situation like this, where the two parties can work together to try to accommodate some kind of a reasonable solution amongst themselves. And so it's just an observation that if something like that were to occur, then everybody is able to come out with something that works for them. So it's just an observation.
Okay. Mr. Jones, is there anything else that you think might be appropriate to approach the HOA about, or is this kind of set in stone what the request is?
It's pretty much set in stone. I mean, we're really limited with space. You know, certainly our client wants to build a building there. We then have to have a septic system. We also have to meet the requirements for parking. And it's just a tight little lot to do all this. So it's pretty well set in stone.
Okay.
Thank you.
Would someone like to make a motion, please?
I'll make the motion to approve case number 20 BZA 11.
Someone like to second that, please?
I'll second it.
I'll second it.
Did you get that, Rachel?
Yes, I did.
Okay. All right, the motion's been made and second. If you would call the roll, Rachel.
Okay. Randy?
No.
Dave Inzera?
No.
Ken?
No.
Dave Lindros?
No.
And Chairman?
No. Okay. The board does not have to explain their decision, but personally, I just want to go on record as saying that I feel I would be irresponsible on my part with the precedence that's been set by this Duncan versus Middlefield on an area variance. There's too many items of the 7 that are there that I think would be compromised in this decision. And if we ever had to go back into court and fight it, we'd have a rough time doing that. So I'm sorry to the applicant, but I just think it's too much for that lot. Okay. All right. So moving on to the next case. Rachel, if you would please read case 20 BZA-12.
Applicant Adam Wallace filed a variance application for property located at 417 Morel Avenue. The request is to allow construction of a deck on the rear of the dwelling, which proposes a rear yard clearance of 18 feet in violation of sections 14.03A1 and 14.03 G2, which require a minimum rear yard clearance of 25 feet.
All right, again, I find no error in our zoning inspector requiring a variance. Is there someone to speak in favor of this request?
Yeah, that's me. Adam Wallace. And basically what we're proposing is a 16-foot, if you can reference the print, a 16-foot width of the deck to the rear lot. And I'll also say that it is fenced in all the way around, as you can reference in the pictures as well. It does step back to 10 feet, which we're only 1 foot over the proper clearance. We would love to have the space. It's kind of a tight back lot. just being so far set back from the street doesn't leave us a lot to go back there. So we need it wide enough for future projects. We're looking to put a hot tub up there. We need, that type of room to facilitate something like that. We've been putting a lot of money into the outside of the house. If you look at the front left pictures that I provided, there's a common lot with our neighbors, Art and Kathy Gustafson, and they're on a fixed income. About 10% of their lots are. So we actually footed the bill to get this thing down and get it looking right. So we're trying to just really invest in the street and hopefully invest in ourselves and making our life a little bit better. Being a ranch, we don't have a basement as well. So any square footage that we can get outside the house and at the point we can ever have parties again, we would definitely love to do that and do some entertaining. The property to the rear is nothing but a wooded area. The house is grown over with woods, so it would not affect their view. It would not affect anything to do with that lot. And again, everything is fenced in, as you can see in the pictures, basically to the front of the house.
Okay. Is there anyone else to speak in favor? Anyone to speak against the proposed request? Thanks, Sean. Any questions of the applicant from the board? Well, I have a quick question. You're Adam, right?
Yes.
Is the deck already there?
Yeah, the deck actually was built. Being a new homeowner myself, didn't really realize the proper guidelines. So after realizing what we did, we had called on our own accord. Nobody stopped over and caught us and said, hey, we're going through the motions to try and make it right.
Yeah, okay. I did pull in and I looked around the corner. I said, I think that deck's already there.
Yeah.
Okay, I got you.
And that's the reason it's awkward, but we're just trying to do it, do the right thing.
Yeah.
All right, anyone else? Questions? Someone like to make a motion, please?
I'll make a motion to approve 20 BZA 12.
I'll second.
And I'll second.
Get that, Rachel?
David Lindros.
Which Lindros? Okay.
All right. Motion's been made and seconded. Rachel, if you would call the roll, please.
Dave Zera?
Yes.
Randy?
Yes.
Ken?
Yes.
Dave Lindros?
Yes.
Chairman?
Yes. And again, since it's already there and we want to just hurry things along with the paperwork, we might as well make a motion to journalize this decision.
I'll make a motion to journalize 20 BZA 12.
Okay.
I'll second.
Motion's been made and seconded. Rachel?
Okay. Ken?
Yes.
Dave Zera?
Yes.
Randy?
Yes.
Dave Lindros?
Yes.
Chairman?
Yes. Okay, thank you. So moving on, Rachel, as soon as you get all your caught up there, we'll let you read case number BZA 20 BZA 13.
13. Okay. Applicant Roger
Principe.
Forgive me, Principe, thank you. Applicant Roger Principe filed a variance application for property located at 90 Wonderlust Drive. The request is to allow the installation of a 4-foot high fencing between the main dwelling and the right-of-way of Foxfire Drive in violation of section 6.13E, which prohibits fences in excess of 36-inch height in a specified area.
Okay, again, I find the zoning inspector correct in asking for a variance. Roger, you just want to tell us what you'd like to do?
Yes, the denial was for a fence in the front yard. It's actually,
Roger, just let our secretary know who we are, just so she can.
Roger Principe, 90 Wonderlust Court, Painesville, Ohio.
Thank you.
The denial was for a 36-inch high fence on Wonderlust. This is for a fence in the backyard, which will go through a small section of foxfire. The 4-foot high chain link fence is over 170 feet away from the intersection of Wonderlust and Foxfire and poses no problem to the field of vision for anybody coming down Wonderlust.
Okay. No one else to speak in favor of the request? Anyone to speak against the request? Any questions from the board? Would someone like to make a motion, please?
I'll make a motion to approve 20 BZA 13.
This is Randy. I will second.
Thanks, Randy. All right, Rachel, if you call the roll, please.
Okay, Ken,
Yes.
Dave Zera,
Yes.
Randy,
Yes.
Dave Lindros,
Yes.
and Chairman.
Yes. Roger, is this something you want to do right away?
Yes, it's supposed to be installed in 2 weeks.
Okay.
I'll make a motion to journalize 20 BZA 13.
I will second that.
Who seconded?
Dave Lindros.
Dave Lindros.
Okay. Okay. Dave Zera,
Yes.
Randy,
Yes.
Ken,
Yes.
Dave Lindros,
Yes.
and Chairman.
Yes.
Thank you.
Okay, good luck, Roger.
Thank you.
All right, so now, Rachel, you read case 20 BZA 14.
Okay. Okay. Applicant Alan T. Manning filed a variance application for property located at 146 Fruitland Ave. The request is to allow a gravel driveway to be installed on this property in violation of the provisions of section 29.06A of the Painesville Township zoning resolution, which requires, among other things, that all driveway surfaces and all parking surfaces in all zoning districts be composed of asphalt concrete, Portland cement concrete, or pervious pavement, as all are defined in section 5 of the zoning resolution, and that all surfaces are to be homogeneous in total.
Okay, Rich, real quickly, I have a question on this. I see that he does need a variance, but I'm looking at the quote from North Shore Seal Coating and Asphalt.
Okay.
Maybe someone can clarify this. He's asking for a stone driveway, and the guy's quoting hot mix asphalt.
Tom, say that again?
He's asking for a gravel driveway to be installed, and the quote that's attached to the application from North Shore Seal Coating, addressed to Alan Manning, is it says grade existing stone, install 2.5 inches of binder asphalt, and so 2 inches of hot mix asphalt, rolling compact. So,
correct. After grading the existing stone, they're going to install an asphalt driveway according to this quote. This is a quote to install asphalt. the way I see it.
Okay, so what we're looking at is just, we're not dealing with the asphalt, we're dealing with a gravel driveway? I think I need that clarified from the applicant. Well, let's move on and we'll get this clarified. If someone could speak in favor of the request, I see you're on, Alan Manning. Do you want to identify yourself and then go ahead and tell us what you want to do?
Yeah, sure. Yeah, my name is Manning. Yeah, I was struggling with that. I apologize. I was trying to get it unmuted. Yeah, my name is Alan Manning, and I'm a new homeowner. This is actually my first house. I've never owned a house. I've lived in trailers previous and never actually lived in township. But what I was do when I first moved in, the driveway was in such disrepair. We were afraid with all the rain that we weren't going to be able to get the truck down the driveway without getting it stuck. And so we laid this down in not thinking that there would be an issue because the previous city I lived in, there wasn't an issue. And we were just concerned with the truck getting stuck. And we figured after that, we moved in, we could figure out what else we had to do. I didn't realize that or gravel at the time was something that was against any sort of. So what we're looking to do now is to apply for this variance to not have to do cement, because the quote that we got for that asphalt that he read off was for $10,140, which is way out of my means to take a new home.
Okay, that clarifies it to me then. You just want to put a gravel driveway in.
I would be fine with gravel if that's what the township would like. I would do that. I was hoping to do something a little bit nicer than that to me would look nicer. But I mean, if the gravel has to be what it has to be, then I'm fine with that.
Rich, the request is for a gravel driveway, which is not allowed. Is that correct?
Correct.
Okay. So, do you understand that, Mr. Manning?
I do, but when I bought the house, I was not aware of the. I was not aware that there was any sort of issues with the driveway. I mean, I went through title company. I went through all these different people that should have let me know, and I had no idea when I bought the house, being a new homeowner, that there was existing issues with this driveway. I was just told that there was no driveway, not that there had been other people that have gone after them to do something. So I was not aware of that, and at the time, I also was not aware that gravel was against any sort of code. I am now, of course, because obviously after talking to Rick, I've been, alerted to that. Previous to that, I had no knowledge.
Okay. Is there anyone else to speak in favor of this request? Is there anyone that's opposed to this request? No?
Yeah, I'm sorry. I'm unmuted now. My name is Bruce Royals. I'm the attorney for Terry and Fabian Medvick. They previously owned 146 Fruitland and currently own the adjacent property. They lost this property to foreclosure. They were working with the bank or got into a situation where they were trying to force the bank to allow them to short sale. And one of the issues that they were using was that the driveway, only a very small portion of the driveway is on 146 Fruitland. And in November of 2019, they had a number of discussions with the township zoning inspector as far as whether or not that driveway would be allowed to be expanded or whether or not a new driveway had to be put in. And Mr. Manning came along and I sent an email to Mr. Constantine because I was unaware of how we would get the document into evidence before the board, given that we're doing this by teleconference. But there was a addendum to the real estate purchase agreement signed by Alan Manning in March The purchase agreement was dated on February 28th, and we had discussions with the real estate agent, the zoning inspector, trying to make everybody aware that there was a driveway issue, that the current driveway couldn't be used, and that any future driveway would require, according to Mr. Constantine's notes to us, that any expansion of the existing driveway more than 10% would have to be asphalt at a minimum. And we were using this with Mr. Manning and his real estate broker because we were trying to force the bank to allow us to short sale it rather than foreclose on one of two adjoining properties. So I believe that Mr. Manning came to the property or purchased the property with knowledge of the situation. And just kind of going down through the Duncan factors that you list on the Painesville website, the property would yield exactly the same return without the variance. He bought the property knowing there was an issue. The property needs to have a driveway, and I believe that this requirement is fairly new, and therefore, while it might not be substantial, it's almost immediately after the zoning ordinance was passed requiring this type of driveway to be installed. He purchases the property knowing of this requirement, and now is concerned that he can't afford to put that type of driveway in. There were numerous offers made to sell the adjoining property. Therefore, he would have had a driveway that would have been a non-conforming use and wouldn't have had to had any type of area variance. The other items, no, it really wouldn't affect the delivery of governmental services. Can the problem be resolved in some other manner? Yes, he can put in the driveway that he knew he was going to have to put in at the time that he purchased the property. And would the variance preserve the spirit and intent of the zoning ordinance? No. Painesville just recently created this new requirement to have a hard compact surface so that the driveways wouldn't be damaged and, mud and slop wouldn't be all over the state highways that go through Painesville. So I believe that we should not be allowed the variance. Both Perry and Fabian Medvick are available to testify as far as the history of the property and the items that were discussed as far back as November, several months prior to the purchase of this property in February, and certainly prior to the purchase addendum that was signed by Mr. Manning in March. Thank you.
Okay, thank you. Anyone else?
Mr. Chairman, this is the zoning inspector. I did receive an email from Mr. Broyles this afternoon that had two documents attached. Our IT person knows that I'm a little bit weak on being able to present material, but I can make my best attempt to put those documents up on the screen for you if you wish.
Sure.
The second comment I want to make is, even though we have had recent amendments to section 29.06 paragraph A, the basic premise that all driveways must be asphalt or concrete, and if any other substances to be used would require a variance, I believe we learned during the Winter Green Hill asphalt driveway debacle that rule was in effect in 1999, which is not recent at all. So I just want to correct that. And I will be at your direction if you want me to put anything up on the screen to the best of my ability.
Well, the thing that, do you have the addendum that was presented in March to the homeowner? Is that part of the thing you're going to show us?
Well,
yes, that was one of the attachments to the email that I sent Mr. Constantine this afternoon.
I just think it would help the board to make a decision if he knew that the applicant was aware of this in writing somewhere, somewhere along the way here.
Well, and if I could, I can read the addendum.
No, I think it's better to see it.
Okay, well, if you're not experiencing any technical difficulty, that's perfect. I'd love for you to share it with the board.
Here we go. We're going to try it. Sean, this is
okay.
Okay. The two documents that Mr. Broyle sent me today are at the end of this file. I have pictures that are historical, a couple pictures from November of 2019, 3 pictures from April of 2020, and 1 picture from May of 2020. But let's take a look at the documents. This is the addendum. Stop sharing. What are you doing? To the, okay. 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 So Bruce, is this the document you sent to me today?
I believe he left the meeting. Oh, I saw him leave the meeting. There he is. Okay.
Yeah, I'm sorry. I hit the wrong button and left the meeting and had to rejoin and then unmute myself. But yes, that's the addendum in which he was aware that there were issues regarding the driveway. And in addition to this, both Terry and Fabian Medvec are there to testify as to how thorough they were in explaining the driveway issue, and that any driveway would have to have, and I apologize that it was 1999. I thought one of the more recent amendments, but that driveway would have to be as an asphalt or concrete porcelain cement process. And truthfully, the reason why this was of an issue to the Medvecs, they were using this issue in an attempt to at least salvage a short sale event of a property that ended up going through foreclosure when Mr. Manning agreed to ignore all the warnings and agreed to purchase the property from the bank.
Okay, board, are you satisfied that you've seen this document? Ken, you're muted, I think.
Yep.
Yeah, I'm satisfied.
Yeah, I'm fine. I'm fine.
A question to Mr. Broyles. This was bought through a sheriff's sale, is that correct? So was there a realtor involved?
It was purchased after the bank purchased it from the sheriff's sale, I believe, and there was a realtor involved. She was with Remax.
Okay.
And that's
I just want to be sure that Mr. Manning was aware of this addendum. You know,
well, he signed the addendum.
Okay, all right.
That's his signature at the bottom.
Oh, I didn't see that. Can you scroll down, Rich?
I did.
Oh, that looks like a what is the auto signature or something?
Yeah.
It's electronic. It's an
Yeah,
electronic signature.
electronic signature. Okay. All right. Thank you.
Mm-hmm.
Rich, you can take that down now, probably.
Okay.
Anyone else to speak against this proposal?
Well, Terry and Fabian Medvick, we're both against it.
And you are a neighbor, or?
I'm Fabian Medvick. We own the adjacent property.
Okay. All right. Any other questions from the board? Someone like to make a motion, please?
I'll make the motion to approve 20 BZA 14.
I'll second
Rachel, did you get that? Rachel, you still with us?
Who?
Sorry, forgot to press on mute. Who seconded?
Ken.
Ken, okay. Second.
Rachel, motion's been made and seconded. If you'd call the roll, please.
Okay. Dave Anzera?
No.
Did I hear a yes?
No,
A no?
correct.
That was his reply, yeah.
Randy?
No.
Oh. Sorry. Randy. Ken?
No.
Dave Lindros?
No.
And Chairman?
No. Okay, does everyone understand that this has been denied, and that if the applicant wants a driveway, he's got to fulfill the terms of the zoning resolution and the amendment from the...
Am I able to say something before this closes by chance?
You are?
Manning?
Just so it's for the record.
All I wanted to say was that in the thing, it said may have issues. And I understood that I took it on knowing that it may have issues, but I didn't know at the time that the issues meant that it was going to have to be something other than gravel or Portland cement or anything like that. I went into this knowing that, you know, I was going to have to deal with blocks in my driveway that blocked part of that driveway, the little driveway I had left, and assumed that I was going to be able to gravel it in lieu of anything else. Did I know that it was actually going to be Portland cement or asphalt? No, because it did not definitely say that anywhere in anything I read. I did read that, and I acknowledge the fact that there was no driveway and that there was going to need to be some resolution. I had no idea that the resolution was going to come down to having to spend over $10,000. I'm a family man. I have a kid. I work for the post office. I'm only a 3-year carrier. I'm not very established. I bought this house and spent every dime of my savings to buy this house, and it was not left in very good condition by Mr. Medved. There's a lot of repairs that needed done. There was carpet. The previous tenants had destroyed this house, and I've done a lot of money and put a lot of money into the inside and the outside, being a first-time home buyer, and spent more than what I should have. And now I don't have the means to pay over $10,000 to asphalt this. I wasn't trying to inconvenience anybody by doing it, and had I known, I would have tried to take the proper steps ahead of time. I was not aware of any of that. The only thing I was aware of when I signed this from the real estate, from RE/MAX, and from everybody else, that there was a driveway issue and that it was going to need to be addressed. I didn't know the severity of the issue. That I was never aware of. Had I known, I probably would have never bought this house. I would have stayed in Mentor and looked at a house that was not going to require me to spend another $10,000 in order to move in or do any of that. So that was the situation that I was in when I bought this house. I moved from a tiny trailer and my family needed a house. So I did the best thing I could to try to make
Mr. Manning,
my family.
Mr. Manning, you know, we like to work with our citizens of the township. Again, it was your responsibility to check that, but I would like to think that maybe talk to our zoning inspector. You might even want to talk to some of our trustees, give you a little grace period here so you can recover some of your funds or do what's needed, but not right away. I would just say, let's talk with maybe talk with one of our trustees or some of our trustees and our zoning inspector. Let's see if we can work something out for you and your family.
I would appreciate that, because right now that's just way out of my means. And I've gotten other quotes, but nothing's been less than, 10,000 or 8,000 or anything like that. And being such a long driveway, sitting so far back, and even the guys that come and do it, there's blocks all the way down this driveway that Mr. Medved did to obviously divide this property to show where there's a property line. And it's going to make it really hard for somebody to even come in with those blocks and pave or reestablish a new driveway with those kind of blocks. So,
Well, again, if we agree to something, maybe we can get those blocks out of there. We certainly don't want to displace a family or anything like that. This board has to deal with what the zoning resolution is. It would have been injustice for us to grant that based on, what the resolution calls for. But I would just see if you can work with them.
Mr. Hill, he had already added on to the driveway enough to where right now he's not, he added on 10 foot, so the blocks aren't even a question. He's already done the work to the driveway and put down gravel. So,
and I will remove all of that. I'll spend the next months removing it.
Granting someone variance could influence us building a house there, and I'm glad the board voted the right way for us. And Mr. Manning could, the lot's for sale, and it's, we're being taxed on the property for. We had it up before he purchased the property. At no time has my wife's name on the real estate side. There's no time he's made an attempt to even make even a land contract offer so he could have a 2-year buffer. Maybe give us $5,000 and then make payments on time for 2 months or 2 years.
And again, it's not our board's decision. It's not our board's duty or obligation to investigate anybody's finances or anything like that. We're just, we did what we really needed to do. And I would just say that if the township can work with him, work with you as neighbors, and make it comfortable for both of you, it would behoove us. I think all of us. So with that, we've got one more application here. If that could be read by Rachel. 20 BZA 15.
Yes. Applicant, Safe Store Real Estate Co. LLC filed a variance application for property located at 1980 Menor Avenue. The request is to extend the term of the conditional use permit 20-BZA-07 to 20 years in violation of section 12.13, which requires that conditional use permits be renewed no less than once every 5 years.
Okay, again, we discussed this at the last meeting. This is an application that I guess they got in just in time to help this building go through. Jeremy, a quick question. Do we have to worry about any legal thing? We did not 15 years going with Tractor Supplies or anything we need to worry about going 20 with these people?
No, as long as you approve it, that will be fine. And it does fit with the financing that they're doing on the 20-year financing. Okay. So it'll be fine.
All right. Is there anyone from Safe Store there to speak in favor of this request?
John Williams is on. Just really appreciate you guys considering this, and I appreciate you expediting and to get it back on the agenda.
Okay, thank you. Anyone against the request? Any questions from the board? If not, if someone would like to make a motion, please.
I'll make a motion to approve 20 BZA 15 as submitted.
I'll second.
Okay, motion's been made and seconded. Rachel, if you'll call the roll.
Okay. Dave Lindros?
Yes.
Randy?
Yes.
Ken?
Yes.
Dave and Zara?
Yes.
And Chairman?
Yes. And of course, we need to get this taken care of right away. So if someone would like to make a motion to journalize it.
I'll make a motion to journalize 20 BZA 15.
Second?
Was
Did
that
you get
Ken
the
that
second,
seconded?
Rachel?
Was that Ken?
Yes.
Yeah, it was Ken.
Okay. Okay, Dave and Zara,
Yes.
Randy,
Yes.
Ken,
Yes.
Dave Lindros,
Yes.
and Chairman.
Yes. Okay. So we have no more applications. With that, we'll close the public hearing. Is there anything else we need to know about any of these, Rich, before we close the public hearing?
Just one question. Who seconded the original motion to approve this last variance?
Ken Sullivan did.
No, Ken moved.
I moved.
Ken made the motion.
I seconded.
I thought that was.
I thought Dave made the motion and Ken seconded it. Wasn't that the way it was, Dave?
No,
That's what I thought.
I made the motion on the variance.
Ken made the motion to approve the variance.
Okay.
Who seconded that motion?
Me, I did.
Dave and Sarah.
In Zara.
Okay, thanks, guys.
Sure.
Part of a virtual meeting. You can't see all the squares at once.
See, the way we want to train ourselves to do this, guys, when we're doing the video conference, is don't say, I move. Say, this is Ken Sullivan. This is Dave Anzera. This is Dave Lindros. I move to do something.
By the time we get all this right, Rich, we'll be back in.
You know, we're going to be back to regular time pretty soon. I think next year or the year after, anyhow.
Please. All right, so has everyone had a chance to review the minutes from last meeting?
Yep.
If there are any questions or changes, I would say that they be submitted as, or approved as submitted, or entered as submitted. To make that happen.
Okay. Rachel, you got that, right?
And actually, I'm going to make a request, Mr. Chairman.
Yeah, sure.
I would actually be more comfortable if when we approve the minutes, we do a motion and a second and a roll call on it. I know in the past we said it was okay not to. I'd be more comfortable if we did.
That's fine. We battled with Matt for a long time getting it to this point. This all started when we didn't have enough people to approve the minutes from the previous meeting. Isn't that correct, Rich?
Well, it was when you're bringing in all the alternates. You had two alternates, and we could never get the same people back for.
Yeah, to approve the previous minutes, and so it was holding things up. That's why he wanted us to do it that way. But you're our legal counsel now. If that's the way you want it, that's the way we'll do it.
It can technically be done that way, but this way, I am more comfortable this way, especially since when we journalize, we do a roll call. I'd be more, since some of these things get approved when the minutes get approved, I'd be more comfortable if we do it.
Let's have somebody make a motion to approve the minutes as submitted then. Make sure you say who you are.
David Lindros. I, David Lindros, would like to make the motion to approve the minutes of last month.
And I, David Anzera, will second that motion.
Okay.
You, Rachel, will you please call the roll?
Would you like me to say, Rachel, roll call?
No, you can just call the roll. I think that's okay.
You would think I would have everybody's name down by now. Ken.
Yes.
Ken. Yes. Dave and Zara.
Yes.
Randy.
Yes.
Dave Lindros.
Yes.
Chairman.
Yes. Okay, Rich, any old business we need to talk about?
I don't think so.
Pardon?
I don't think so.
Okay, new business, none? That's what it says.
Nothing from the zoning inspector.
Okay, before we adjourn, I would like to thank Rachel for stepping in. This was not our usual quick meeting. It was kind of, a lot of people chiming in, and thank you very much for your patience. You did a great job from what I can see here.
Thank
Okay,
you.
board, thank you again. Harley, you there?
I'm here.
Okay, I just wanted to hear your voice. We haven't heard from you too much tonight.
I spoke a little bit.
Okay. All right, with that, if nothing else, we'll adjourn this meeting and wait for the next one. Does anyone know if they're not going to be around in August? Let's just put it this way. If you can't make it, please let Rich know in plenty of time so we can get our alternate up to speed on this. I don't know if the next one's going to be virtual again or not, so we'll just play it by ear. Okay. We'll cross that bridge when we get to it, I guess. All right. I want to thank everybody. It was, this was an hour and a half. That's one of our longer ones. Okay.
Tom, that was good.
All right. Thanks, everybody. We'll talk to you later.
Everybody stay safe.
Okay.
Bye.
Bye.
Bye, everyone.
Bye-bye. Bye-bye.